Salduz versus Turkey is a Grand Chamber decision. The decision of the Chamber had actually followed the already established line of jurisprudence on the issue tackled in Salduz, which was the right of early access to a lawyer, to legal assistance. Salduz was a young 17-year-old Turkish boy of Kurdish nationality who was a member of a nationalist party which was allegedly had some links with the PKK. The PKK is a famous organization in Turkey which is still involved in an armed conflict with the Turkish state. Allegedly he was taking part in a demonstration organized by this party supposedly in support of the PKK. He was arrested during this demonstration, brought to the police station, and he was not offered legal assistance. He was questioned repeatedly by different authorities, and already at his first interrogation by the police, he has admitted that he took part in this demonstration and that he was a member of that that nationalist political party. Then, when he was questioned again, he denied that he participated in this demonstration. However, during his trial, the court had relied on his first statement made to the police and said that his subsequent statements were not truthful, so he was in the end convicted. The case has reached the ECtHR. The ruling of the Chamber was that Article 6 of the European Convention of Human Rights was not violated by the fact that Salduz was interrogated in the very beginning of the proceedings without access to legal assistance. This was based on the fact that, according to ECtHR, Salduz has enjoyed the guarantees of a fair trial at the subsequent stages of the proceedings, and that there was also other evidence in the case supporting his conviction. So his initial admission was not the only piece of evidence in the case. The Grand Chamber of the ECtHR has, however, disagreed with the ruling of the Chamber. What they said is that the fact that Salduz has made the admission, and this admission has been used in a conviction against him as an important piece of evidence, has undoubtedly affected his position in the criminal case. The Grand Chambers effectively said that what was important is not the fact whether or not Salduz would have been convicted without making this admission. The court has also carefully elaborated on the rationale for the right of early access to a lawyer, and particularly for suspects who are kept in detention or in police custody, saying that it serves as a safeguard against torture and ill treatment, but also guarantees the equality of arms in the beginning of the criminal proceedings when the suspect is in its most vulnerable position. This is one judgment of the ECtHR which has probably caused the most reaction, both on the European level and among the member states, and the most legislation or case law that have been adopted as the result of this decision. But there was also a lot of controversy and debate, both on the European level and the national level, on how to interpret the judgment and how far states should go in implementing this decision. And to what extent can the European institutions dictate or determine for the member states what their procedural legislation should look like. a number of states, such as France, the Netherlands, or Belgium, have resisted implementing Salduz to the full extent, or accepting or fully accepting the rationale behind this decision. And this is linked mostly to the fact that these states have an inquisitorial procedural tradition where historically the right of access to legal assistance or an active role of a lawyer in the pretrial proceedings have not been recognized. In the Netherlands, for example, it took over 8 years after the Salduz judgment that the right of access to a lawyer also during police interrogation was recognized for all criminal suspects. And still now there is certain restrictions on the role of a lawyer during the interrogation, so on what the lawyer can or cannot do in the course of interrogation of a suspect. The European Court of Human Rights has also, in the early days after the Salduz judgment, adopted a number of judgments which have added upon the findings in Salduz. For example, Pivaty versus Russia or Detained versus Turkey case. Recently, there's also been a setback in the line adopted by the European Court of Human Rights on the issue of the right of early access to legal assistance. This setback was particularly evident after the Ibrahim and others versus UK case. Some commentators would say that Ibrahim and post-Ibrahim jurisprudence mean that the progress that was made in Salduz has been entirely reversed. Now, whether this is so and what are the possible reasons for this new trend, we will discuss in the next video.